Resume your closing argument.
Thank you, Your Honor. So I wanted to, I just wanted to speak for a moment about burden shifting and say that, can you hear me, Your Honor? Okay, thank you very much, sorry. Great, so I just wanted to take a moment and talk about burden shifting and say that plaintiffs have to show that SB 824 was in fact motivated by a racially discriminatory intent to shift the burden. And even if, and they haven't done that, but even if they were to, then we would be able to meet the burden by showing that North Carolina has a constitutional amendment requiring it, and that there's nothing about this particular law that exacerbates whatever conditions may have been created by that requirement. And that evidence was not before the Court of Appeals in terms of the fact that Dr. Quinn's full analysis and the cross-examination. Now, let's talk about the Arlington Heights factors, and we'd like to start with history. And as we said in the opening, this state has a shameful history of racial discrimination, but North Carolina has come a long way, and it has always stood apart from other southern states. By 1991, the Speaker of the General Assembly was an African American. Today, 20% of the General Assembly is comprised of African American members. And in 2008 and in 2012, African Americans outvoted whites in the state of North Carolina, demonstrating that they were able to overcome the prior effects of discrimination, the effects of poverty, to participate fully and even at rates higher than whites in this state. Now, plaintiffs' historians present the court with a boom and bust theory of discrimination in which progress is made and then there is retrenchment. But this law, which allows all registered voters to cast a vote, stands in stark contrast to the types of laws that these historians were pointing to. I'll take the historians one at a time. Professor Anderson admitted on cross-examination she had not even read SB 824. She simply ignored the cases and the evidence that didn't fit within her pattern. She explained that she ignored the cases that upheld voter ID because, quote, they didn't add to the analysis of the pattern of legislatures using law to figure out race-neutral language to undermine African Americans' access to the ballot box. So she started with a pattern and then ignored any evidence that didn't fit within the pattern. That's the opposite of the way history is supposed to work, where you look at all the facts, all the evidence, and then you see if there's a pattern. Now, Professor Lolotis, his conclusions turn on a purported impact. And the only impact that he was able to point to was a heavily criticized turnout study. He concedes that if SB 824 had been in effect, it wouldn't have even been included in the study, which focused on strict voter ID laws. And of course, there are stark differences between the literacy test and the poll test. We've got up on the screen the fact that Professor Lolotis had shown in one of his tables, there was a 100% decline in African American voting rights under the poll tax and the literacy test. Here, what we know from March of 2016 is that 99.9% of the electorate showed up with qualifying ID and was able to vote. And what did the General Assembly do? Confronted with 99.9% of the people able to vote, they drove the number of people that could vote even higher. This approach cannot be squared with the legacy of Jim Crow. Now let's talk about disparate impact, and this really is the crux of plaintiff's case, where they're asking you again to infer invidious racial discrimination based on disparate impact. And we'll get into Professor Quinn's numbers in a moment, but there are some threshold issues I'd like to address. First, all agree that the General Assembly did not have specific knowledge that SB 824 would disparately impact voters of any particular race. Now, when the General Assembly considered 589, it was required by Section 5 of the Voting Rights Act to consider the law's potential racial impact. But by the time SB 824 had come along, that requirement was no longer in place. And a race-neutral actor, freed from the requirements of Section 5, would presumably not look to see what the racial impact of the law was. But a legislature trying to entrench itself by targeting a particular racial group would absolutely want to know what the racial impact is. But the General Assembly did not seek that information. Neither Republicans nor Democrats sought it. Nevertheless, the General Assembly did obtain some data from 2016, and what they learned was there was record turnout in March of 2016, that 99.9% of those who showed up to vote were able to vote, that the no match list, they learned, was wildly over-inclusive, in that 91% of the people who responded to a survey from the no match list said, we have qualifying ID. And the legislature made it easier to vote. Does anyone think that a legislature trying to entrench itself looks at March of 2016 with 99.9% of the people having qualifying ID, and then expands the number of qualifying ID, expands the reasonable impediment provision, and thinks that's the way they're going to entrench themselves? Their theory of the case collapses on itself, and there is another insurmountable barrier for the plaintiffs' efforts to try to impute discriminatory intent from disparate impact. Specifically, the foundation of their showing of disparate impact is the disparity between the possession rates of driver's licenses between whites and blacks. It's critical to understand this, because for the court to brand the General Assembly with having had a racially discriminatory motivation, it must conclude that the inclusion of driver's licenses as a qualifying ID was done to target African Americans. And that can't be right. Every state in the union includes driver's licenses. Why? Because they're the most readily available. And so unless this court is going to explicitly say that the General Assembly's inclusion of driver's licenses was an intentional act of racial discrimination, then the disparate impact claim goes away. We win, full stop. And there's another problem, dispositive problem, with their theory of the case, which is if we just focus myopically on driver's licenses, as they're essentially asking the court to do, there are 140,000 more whites on the no match list than African Americans. And in a state in which we are told by Mr. Brockman that there's racially polarized voting, it wouldn't make any sense for Republicans to look at those numbers and say, let's on net kick 140,000 white voters off the rolls. Plaintiffs also have a hip bone connected to the thigh bone theory of impact. They say, well, the way Republicans were really getting at this was by targeting low-income voters. And there's several problems with this argument. Number one, there's not a scintilla of evidence to support it. Number two, the statute itself refutes it because it creates a free ID. And the free ID is available at one-stop voting so that there's no marginal, no additional, no incremental cost associated with getting that ID, even in terms of transportation costs. And in addition, African Americans have already proven in North Carolina that notwithstanding the legacy of discrimination, notwithstanding the higher poverty rates, they can participate at rates higher than whites in the political life of this state. And so they're able to overcome the burdens of poverty. There's another critical flaw, and that's that the plaintiffs use the wrong baseline. They're asking the court to assess disparate impact as compared to there not being a voter ID law. But we know there has to be a voter ID law. So this court needs to try to assess the disparate impact of this law against a baseline world in which there's a voter ID law. And if one accepts the proposition that there's going to be driver's licenses included, then they've done nothing to show that there's any incremental disparate impact from this law over and above a baseline world in which there's photo ID with driver's licenses that count. Now, Professor Keegan Callanan looked across the country and he testified that this photo ID law in North Carolina is flexible and it's relatively accommodating as compared to other laws. And this is one of the most generous voter ID laws in the country. I defy the plaintiffs to point this court to a law that is more generous to voters, allowing voters to actually cast ballots than this law. We were told that turnout is a straw man. And if they want to say it's legally irrelevant, that's fine. But just to point out what the record is on this, we had record turnout in March of 2016. That's not disputed. And Professor Trey Hood put in a study from South Carolina showing that there was very little effect on turnout and that actually the little effect there was fell more heavily on whites than African Americans. So in South Carolina, African American relative voting power increased after the voter ID law was put in place there. And since the laws are similar, we can expect similar effects here in North Carolina. This is the most apt turnout study because the record shows that SB 824 was modeled on South Carolina's law. Now let's talk about their implementation theory. They had a variety of witnesses, Professor Ariel White, Kate Fellman, Professor Harrison, who said, look, there could be implementation problems that lead to disparate impact. As an initial matter, I would point out that these concerns are legally irrelevant. Professor White admitted there is a risk of implementation problems with any election regulation. And her opinion was incredibly tepid. Note, she kept saying that there could be an implementation problem. And when I asked her, well, do you have a probability? Can you tell me whether it's likely that there's going to be an implementation problem? She said, no, I can't put a probability on that. But voter ID is mandated in this state. So these theoretical observations are irrelevant. Now, Ms. Feldman offered her non-expert views based on second and third-hand accounts of what voters from a non-representative sample told her. These are voters who her organization targets who are those who are confused. None of that evidence was before the General Assembly, and so it can't be used to impugn the intent of the General Assembly. But the risk of implementation problems here, the evidence shows, is negligible. Again, 99.9% of those who showed up in March 2016 were able to vote. And that reality forecloses Professor White's assertion that there may be widespread voter confusion. And given that 99.9% of those who showed up had qualifying ID, we don't need to speculate about the efficacy of the state's educational efforts. We heard from Ms. Strzok that the state board knows how to get the word out about voter ID laws. And interestingly enough, Ms. Feldman gives us reason to believe that the 0.1% of people who didn't have qualifying ID, that's the high watermark of that problem, because she said that people get habits. And so as people get in the habit of complying with this law, we can expect that it will come down. And of course, the General Assembly was not insouciant about having 0.1% of the people without photo IDs. They made more photo IDs available. They made the reasonable impediment provision more sweeping. and they mandated aggressive voter outreach. I asked in opening, I asked the question, why would a General Assembly that wanted to entrench itself by having people not vote, why would it mandate 4 mailers to every household in the state? And the plaintiffs did not put on one word of evidence about that. And there's no answer to it. We don't need to speculate about how the reasonable impediment process works. It works very well. Of those who cast ballots in March of 2016, 0.01%, 0.01% of those ballots were rejected, 184 ballots. And the General Assembly knew this information about the effect of HB 589 from a presentation from Ms. Strzok. And what the General Assembly knew is what matters to its intent. They also knew that it proved that the county boards were not going to arbitrarily enforce this provision. And if we look at the 184 ballots that were rejected, we see that 5 actually counted, so it's really 179. We see that 10 ballots were rejected for non-photo ID problems. So whatever problems they weren't photo ID issues. 50 of them were rejected because alternative ID was not present. Remember, that's no longer a requirement, so those 50 ballots would have counted. 36 had no reasonable impediment listed, but were cast during early voting. So now that there are free IDs available, presumably if there were a problem with those 36 individuals, they could just go and get a free ID at that time. There were at least 10 ballots where the person forgot the ID or kept it out of state, and recall that that's a change from 589 to 824, that now if you've forgotten your your ID, that counts as a reasonable impediment. It did not back then. If we go and we look at, take sort of another cut at this, at the 184 ballots, 81 of them were cast during early one-stop voting, and 50 of those were at Duke's campus alone. And so those individuals, of course, would have a couple of options. Number one, they could have their Duke ID approved and vote on that basis, or two, they could get a free ID at that time. So the record's clear that confronted with 184 ballots that didn't count, the legislature wanted to drive that much lower and really try to do whatever they could to eliminate it. Now, Professor Lolotis tells you that having to check the boxes on the reasonable impediment ballot form stigmatizes people on the basis of their socioeconomic status. There's no theory for this, and of course, socioeconomic status affects people of all races. Moreover, the boxes that a voter can check on the reasonable impediment form are not inherently linked to poverty. People of all income levels fall within these categories. People lose their IDs. All people can be busy at work. People from all walks of life can be responsible for a loved one. They can be sick. They can be disabled. These conditions affect rich and poor alike. And so Dr. Lolotis's speculation that there's going to be some stigmatization just don't hold water. Now, we heard about voter confusion, and the General Assembly could have made this a lot less confusing. It could have said only driver's licenses count, period, full stop. That would have complied with the Constitution. They didn't do that. They added all these other types of licenses. They added a reasonable impediment provision. The other side comes up and says, well, this is going to be confusing. These are ameliorative provisions which were not required by the Constitution, but which they put into the law. And we've also, Professor White and Ms. Feldman's worries about election administration, really the testimony we've heard from those who are most knowledgeable refutes it. Mr. Reed was asked, you and your staff would make every possible effort to ensure that every vote counts, wouldn't you? Yes. And Brinson Bell said much the same thing, as did Kim Strzok. Now, under the plaintiff's theory of the case, the General Assembly under plaintiff's entrenchment theory, they must be disproportionately prevented, African Americans must be disproportionately prevented from voting in substantial numbers. And in this regard, rates of ID possession do not matter. What matters are absolute numbers of voters. For the entrenchment theory they're advancing, you need to look at absolute numbers. Take a scheme to disenfranchise 1,000 people. Assume that this is a voting population that has 20% African Americans. And further assume that of those in the scheme, this subset who are going to be disenfranchised intentionally, 300 of them are African American. Well, that would be a rate, if it was just proportionate, you'd have 200, now you have 300, so that's a 50% higher inclusion rate. But if you think about that, you would see that 700 whites would be disenfranchised. On net, 400 whites would be disenfranchised. This isn't a way to entrench. When you're looking at entrenchment, you have to look at the absolute numbers. And if we look at the absolute numbers from Dr. Quinn, which are on the screen, we see that African Americans are deemed under the no match list to have 113,000 of them, and there are 253,000 whites. And so that proves that for this entrenchment theory, it doesn't make any sense, because they would have been the General Assembly, if the plaintiffs are to believe, were kicking off knowingly on net 140,000 white voters in a state where we are told there is racially polarized voting. Plaintiffs' own experiences also refute their claims of disparate racial impact. None of them had difficulties voting in March 2016 because of their race, and all have multiple ways to vote under SB 824. Mr. Holmes' mother candidly admitted that they just stopped their efforts to try to get qualifying ID under SB 824 when he became a plaintiff in this suit. And as I've mentioned, there are a number of ways he can vote. Mr. Kearney has 3 forms of ID that count, and Mr. Smith has a North Carolina's driver's license. As I've mentioned, voters can obtain free IDs during one-stop voting. And the evidence confirms that African American voters disproportionately use one-stop voting, and thus are disproportionately benefited by this provision. And we can see, as we put up on the screen, that early voting hours rose in 2016. And again, I asked in the opening, I said, why would a legislature trying to target African American voters make a free ID with no documentation available at one-stop early voting when they knew that African Americans disproportionately used that method of voting? We haven't heard one scintilla of evidence answering that question. And of course, there is no answer, because a legislature targeting African Americans never would have put that provision into SB 824. Now, SB 824 itself leaves open many options for providing free IDs during one-stop voting or on election day. Plaintiffs have tried to suggest that Senator Ford did not know what was in his own bill, but the text of the law is what governs, not emails between staffers. People don't interpret statutes based on staffer confidential emails. They interpret them based on the text of the statute. And the text of the statute says that free IDs shall be issued, quote, except during the period of time between the end of one-stop voting for a primary or election as provided in GS 163 and election day. The key word is between the close of one-stop voting and election day. And it's certainly a plausible interpretation to interpret between to mean that come election day, you can start issuing these. Again, nothing in this law prohibits that. A plausible reading is it's required, and what the state board did in their regs is not relevant to this legislative intent point. And nothing in the text prevents Senator Ford's understanding of it from being implemented. And even if between did not mean between, that would not have a material difference given the generous, reasonable impediment provision in this. Plaintiffs make no effort, none whatsoever, to quantify the effect of these free, no documentation IDs being available. Professor Quinn admitted he had no basis to quantify how many free IDs would be moved. And no one else on their side tries to quantify the impact. Plaintiffs can't simply ignore the ameliorative provisions of the law and be deemed to have met their burden of proof. This is a gaping hole in their disparate impact analysis. Plaintiffs also contest whether the free IDs are actually free, and they point to Professor Louloudis, who claims that, look, in his report, he says there are expenses, and he went through them. You can see them on the screen. He talked about the cost of birth certificates and legal counsel, and he admitted on cross-examination that since there's no documentation required, all of this is irrelevant and can be ignored. So then he sort of switched to saying, well, because there's a higher rate of poverty among African Americans, that will somehow be an impact or a barrier to full participation in voting. And we've talked about how African Americans outvoted whites in 2008 and 2012. And any barrier of poverty is significantly reduced here because the free IDs can be obtained at the same time as voting. So there's no additional incremental cost. Furthermore, even if poverty were a barrier to voting, it would disenfranchise more whites than blacks. Professor Louloudis testified that 10% of white North Carolinians are below the poverty line and 21% of black North Carolinians. Let's do the math. Whites are 70% of the population of the state. 10% times 70% is 7. So that means out of every 100 people in the state, 7 are poor whites. If you multiply the African American portion of the population, 22%, times the 21% that are below the poverty line, you get 4.6. So for every 100 people in the state of North Carolina, you have 7 poor white individuals and you have 4.6 poor African American individuals. Again, this is not a tool of entrenchment in a state where we're told there's racially polarized voting. And of course, Republicans didn't do any of this because they made it maximally generous to voters in the sense of you can go one stop, if you're there to vote, you can get your free ID at the same time with no documentation necessary. Now, I would say that Professor Quinn's analysis, we're going to turn to now, and his analysis is misleading. You see the chart on the left that they put up in the opening. And really, if you look at the right-hand side, where we say in the 2008 election, the difference in qualifying ID between registered voters, white voters, 98.86%, and registered black voters, 97.67%. That's Professor Quinn's numbers, 1.19% differential. And that means that for every 100 white voters in the state, according to Professor Quinn, 98.86% of them had qualifying ID. And for every 100 black voters, 97.6% have qualifying ID. And as the numbers go down, the rates go higher. So if you had, let's say, a law that disenfranchised 2 people out of 10 million in the state of North Carolina, and one was white and one was black, given that whites are 3.5 times more prevalent in the population, then the rate increase would be 350%. even though it's only 2 people. So the rate gets higher the fewer and fewer people that are affected. Respectfully, the court should look at the fact that 98.8 and 97.6 are able to qualify. That's the more relevant fact, not this cherry-picked 39% number. The court should also not credit Professor Quinn's testimony because he admits it's incomplete. He did not consider 7 different types of qualifying IDs: passports, military IDs, veteran IDs, tribal IDs, out-of-state driver's license, local government employee IDs, public assistance IDs. With a narrow or reasonable impediment provision in place, in 2016, 99.9% of the people were able to vote. And Professor Quinn and the plaintiffs don't dispute that. They simply asked this court to ignore that number. He also did not consider, as I mentioned, the prevalence of free IDs in other states or their availability in North Carolina beyond what was issued in the brief period when SB 824 was enjoined. And let's put some numbers on these. If we look at the bottom of the slide, we can see for the federal IDs missing, this resolved, there were 180,000 matches in 2015. That's not a small number. In terms of the inactive status / removed, that will be those who will be removed from the rolls in 2021, that's 800,000 records. And there were over 100,000 students with IDs that he was not able to determine their racial composition. Accordingly, his analysis on its own terms doesn't answer the question, how many, on a percentage basis, African Americans and other racial groups lack qualifying IDs? And even so, the number of African American voters who Professor Quinn thinks lack qualifying ID, he admits that even based on his incomplete analysis, it's gone down significantly. It's been chopped by more than half. You can see about Curry, which was the state court case, and then you can see what happened in SB 824 according to his numbers. We heard today criticism that we haven't put on our own numbers. That's not our burden. Dr. Thornton was not required to put on these numbers, and we simply pointed out the myriad of flaws in their failure to meet their burden, which is our right. Undisputed evidence confirms that North Carolina voters have few issues with ID possession. You know, Ms. Fellman testified that her organization contacted 100,000 voters between 2014 and 2016. And these weren't picked at random. They focus her organization on people who tend to be confused or might be at risk for not voting. Of those 100,000, only 169 lacked qualifying ID under 589. That's 0.17%. So among these at-risk voters, 99.83% of them had qualifying ID under 589. And of course, we know there are many more IDs that are available now. We know that there was record turnout in 2016. And it just, when you look at the record turnout and you look at the percentage of people who showed up with ID, it just explodes the notion that there are somehow a large number of people who don't have qualifying IDs. It just can't be squared with the facts that are undisputed. And the General Assembly knew all of this when they passed SB 824. Now let's switch gears and look at the sequence of events. All agree there was no parliamentary rule that was violated in passing 824. The plaintiff's own witnesses admit as much. Neither Ms. Fairs nor Representative Harrison nor Senator Robinson could cite a single rule that was violated. Indeed, Ms. Fairs confirmed that the General Assembly did not in any way exceed its authority in passing SB 824. And the only intent that's been identified by Representative Harrison was to pass the law before Governor Cooper would have vetoed it. And make no mistake, Governor Cooper would have vetoed any of these laws. You can read his statement, JX 687, and you can see he is adamantly opposed to these types of laws. And plaintiff's basic argument is that by acting during the lame duck session, the General Assembly violated legislative norms. But Professor Callanan actually looked not only at North Carolina, to be sure he did, but also at the federal level and across the country, and said what would have been abnormal was not acting on SB 824, that it was perfectly rational to move while they still had their supermajority. And he has shown that lame duck sessions after power shifting elections are very common. Plaintiffs also tried to dismiss Democratic legislators' work on the bill as largely meaningless, but these were all the amendments that the Democratic caucus wanted to present. The plaintiffs' legislators have confirmed that Democrats had opportunities to present all of these amendments during the legislative process. This is another insurmountable barrier to plaintiffs' case. They claim that this law was a tool of Republican entrenchment, yet they had no additional amendments to improve the bill. Now, Senator McKissick said yesterday, if I had had more time, I would have been able to think of some amendments. This issue, voter ID, has been debated in North Carolina from 2011 to the president. He had plenty of time to think about an amendment, ameliorative amendments, and they had not. Now, if we look at the legislative history, plaintiffs dispute that SB 824 was bipartisan and has tried to show that Joel Ford really wasn't a Democrat. And they're telling he's merely a Republican prop. And you've heard what Senator Ford had to say about such smears in the past. And Senator Ford explained that it's hurtful when you have to resort to tactics like calling someone such as himself a prop when all I've ever done for my local community and state was try and serve. You may not like the way I served, but one of the things you cannot take from me is my intentions and my impact that I have been able to accomplish when I have been empowered with authority and power to affect change for my community. And so it's incredibly demeaning to Senator Ford to suggest that he was somehow either duped into sponsoring this bill without knowing what was in it, or that he somehow targeted members of his own race. Bipartisanship, I would add, is not a requirement under Arlington Heights. What is striking is that there was any bipartisanship. Everyone admits that the Republicans didn't need a single vote or a single Democratic sponsor. They could have just jammed this through. And instead they accepted 7 of the 13 amendments from Democrats. And it's telling that the Fourth Circuit, when they upheld Virginia's voter ID, noted that, quote, while there was a substantial party split on the vote enacting the law, 2 non-Republicans, 1 Democrat and 1 independent, voted for the measure as well. As I've previously mentioned, 20% of the Senate Democratic caucus voted for SB 824 at one point or another. 2 Democratic representatives voted for the bill. The majority of the Democratic amendments were accepted. This was, even though it's not a requirement, a bipartisan process under any normal understanding of that term. If the General Assembly's goal were to prevent groups from voting on the assumption that they vote Democratic, it is implausible that any registered Democrat would have voted for SB 824 at any part of the process. And yet here we have a Democratic co-sponsor, and we got votes from 4 other Democrats. And those 4 other Democrats were all caucusing with the Democratic Party. It's also implausible that multiple Democrats would have thanked the bill's sponsors for the inclusivity of the process if this was simply a matter of decorum. Let's look in 589. Senator McKissick did not thank anyone. He said, this bill greatly concerns and disappoints me. This basically reverses decades of progressive legislation that we've had here in North Carolina that have increased voter participation. Now in SB 824, he says, I'd like to say thank you to Senator Daniel and Senator Krawiec for their work on the bill and for being open and inclusive in listening to us on the other side of the aisle and trying to come up with something that is reasonable in terms of its approach. So I want to say thank you for that effort. And so that's important because he's specific about what he's thanking them for, being inclusive in listening. Representative Harrison here, she's attacking 589 for being saying it was going to be modeled on Georgia and Indiana, but at least they allow for college IDs. And we've taken that out in this conference report. So she's attacking 589. Let's see what she said in SB 824. She said, I did want to start by thanking Chairman Lewis because I think he's done a terrific job working with us to help improve the bill. And this bill is a much better bill than the bill that left this chamber in 2013. So I want to thank him for that. And she continued, I want to thank Chair Lewis and the rest of the committee for working with us as we tried to improve this bill. Senator Ford has been working on the voter ID issue since 2013. He was in dialogue with legislators on both sides of the aisle during the passage of SB 824. His testimony about the motivations behind the bill are the most credible the court has heard. And they're unrebutted. He has spoken about the race-neutral reasons why he supported the law, and they have not actually produced a single witness who has said, it was done for a racially discriminatory purpose. So this isn't a he said, she said circumstance. It's a he said and a silence circumstance. Whether he was caucusing with Democrats is irrelevant. Plaintiffs ask you to find that Senator Ford targeted African Americans for disenfranchisement. Really? Did they step away from the WebEx while he testified? There's no way to have heard his testimony and concluded that he was trying to target African Americans. Neither was Senator Davis and neither was Senator Clark. And there's no middle ground here. You either, to rule in the plaintiff's favor, you have to either find that these individuals were duped or that they were intentionally targeting members of their own race. And they don't even come close to proving that, not for Senator Clark, not for Senator Davis, and not for Senator Ford. I'd like to make some other miscellaneous remarks that aren't tethered precisely to the Arlington Heights factors. There's been a discussion about the process of enacting the constitutional amendment. Again, that's not relevant. They haven't challenged that here. There's been reference to the Fourth Circuit Court of Appeals. It's important that the plaintiffs like to cite the McCrory case over and over again, but what the Fourth Circuit has said, which is bound, Fourth Circuit is bound by the findings of McCrory, and they've said, nevertheless, this law should not be preliminarily enjoined. It's obviously relevant that another court has held that the plaintiffs are not likely to succeed, even if it may not be binding. And the Fourth Circuit held that it would be a mistake to penalize the General Assembly because of who they are rather than what they did. And that's exactly the mistake you are being invited to make by the plaintiffs today. You've been told throughout the case that voter impersonation fraud isn't real. That contention isn't relevant to the proceedings before you because we're not here to decide whether voter ID is good or bad policy. The state's voters have already mandated it. Professor Callanan has shown that there is support in the existing scholarly literature for the hypothesis that voter ID laws can improve voter confidence. And evidence from this state shows why that would be. Plaintiff's own expert, Ariel White, testified that voter ID could deter ballot harvesting. Ballot harvesting is the exact type of fraud that occurred in North Carolina at the same time the voters were voting on voter ID. And that's why Senator McKissick's website updated to his constituents about evidence of, quote, rampant voter fraud, close quote, leading to what his website called a, quote, significant, close quote, change to SB 824 in reaction to what his website called rampant voter fraud. Professor White also admitted, as she must, that the state has a right to know who is voting. And of course, photo IDs help determine who is actually voting. Voter fraud is a risk when you have a large group of voting age individuals living in this state, even though they are ineligible to vote. And plaintiff's own evidence proves that is the case in North Carolina. Professor Louloudis has shown the chart that's on the screen now, where the light blue lines represent tens of thousands of non-citizens living in North Carolina who are voting age. These non-citizens can register to vote without presenting a photo ID and then proceed to vote, even though they are ineligible to do so. And scores of them did so in the 2016 election, as did 441 felons who are also not eligible to vote. And that's according to Professor Louloudis. As the court knows, the most recent election for North Carolina Chief Justice was decided by 401 votes. North Carolina is entitled to ensure the integrity of its elections, and it's entitled to ensure that close elections are decided by lawful voters, not felons and illegal aliens. In conclusion, it bears emphasizing that all of the plaintiff's evidence and arguments would apply to any photo ID law. Take a few examples. Professor Anderson believes any voter ID law will repeat past discrimination. Senator Robinson testified she thinks all voter ID laws are inherently discriminatory. Professor Quinn cannot point this court to any array of photo IDs that would eliminate the disparity he claims to have found. Professor White has doubts about poll workers' ability to accurately and fairly implement a voter identification requirement in this state. The North Carolina Constitution, however, requires voter ID. If SB 824 is not lawful, then the General Assembly can't pass one. Your Honors, you have before you one of the most sweeping and generous voter ID laws in the country. You have a law that was sponsored by an African-American Democrat. You have a law that 4 Democrats voted in favor of and another supported after second reading. 3 of those 5 individuals are African Americans. You have a law that allows every registered voter, with or without an ID, to cast a ballot. Indeed, every single individual plaintiff will have their ballot counted. These are not the acts of a legislature trying to intentionally discriminate against a minority to entrench itself. These are the acts of a legislature trying to fulfill their mandate to implement voter ID laws. And there's a reason why Democrat after Democrat, both those who supported the law and those who didn't, got up and stood up and thanked the Republicans for listening and being inclusive. And that's because this bill, with its sweeping, reasonable impediment provisions, ensures, as Joel Ford said, that even the least sophisticated among us will be able to vote. Thank you.
Thank you. It's now, according to the clock right there, 11:19. I showed that the legislative defendants have used approximately 70 minutes of time. That leaves a little bit for Mr. Cox, who will be giving the closing arguments on behalf of the state defendants.
I will, Your Honor. And for clarification, is there a set time limit for me to present?
Well, maybe I shouldn't have even mentioned the time, but originally I thought the agreement was basically 1 hour and 40 minutes apiece, and so I'm just trying to call that out. Hour and 40 minutes is 100 minutes. So he's used 70, so that would mean you have roughly 30 minutes left if we're if we're going to hold you to the timelines that you set for yourself, then that would be the bar. So.
Understood. I just wanted clarity on the number you're using. I have no plan to go anywhere near that amount of time.
Okay, fair enough. You may proceed.
All right, thank you. Judge Poovey, Judge Rozier, and Judge Opfalu, for the record, I'm Paul Cox with the North Carolina Department of Justice, representing the state and the State Board of Elections. As with the state defendant's opening statement, in this closing argument, I'm not going to retread all the ground covered by Mr. Thompson on behalf of the legislative defendants. The sole claim in this case is that the legislature engaged in intentional discrimination when it enacted SB 824. As a party to this action, the legislative defendants have mounted a fulsome defense as to the legislature's reasons for enacting SB 824, covering all the evidence and argument pertaining to the Arlington Heights standard. In my presentation, I first wish to focus the court's attention on one particular aspect of that test, namely what the law does from the perspective of elections administrators. And second, I'll address whether the state's election officials are capable of implementing SB 824 in a non-discriminatory way, which they are. On the first point, what the legislature wrote into the law is probative on the question of its motivations. SB 824, as enacted, carries out the requirements of the North Carolina Constitution that, quote, voters offering to vote in person shall present photographic identification before voting, end quote. That provision required the legislature to enact a law implementing the photo ID requirement, which could provide for exceptions. SB 824 does that. SB 824 provides a list of officially sanctioned photo IDs for voting. The most common form is a DMV issued driver's license, but as the state board's executive director, Karen Brinson Bell, testified, after accounting for student and employee IDs, public employee IDs, more than 150 types of photo ID have been approved for use in voting under the law. The evidence presented from both plaintiffs and legislative defendants showed that the vast majority of North Carolina voters possess one of the acceptable forms of ID. Of course, the evidence also showed that some North Carolinians do not possess the ID as just described. The exact number of those without ID and the percentage difference between white and black ID possession is in dispute. I won't wade into that dispute. As the state board's chief information officer explained, Brian Neesby that is, there are inherent limitations to matching divergent databases to determine the precise number of people lacking ID. But I will say that the significance of that dispute is limited because whether someone possesses ID or not, they are allowed to vote under SB 824 and to have that vote counted. It is for this reason that North Carolina's law, in comparison to photo ID requirements in other states, has been deemed to be relatively, quote, non-strict by the politically neutral National Conference of State Legislatures. It is also for this reason that the Fourth Circuit recently concluded, quote, the 2018 voter ID law is more protective of the right to vote than other states' voter ID laws that courts have approved, close quote. As from the NAACP versus Raymond case, the Fourth Circuit case that was decided in 2020. The Fourth Circuit went on to explain, in evaluating the impacts of the 2018 voter ID law, the court must adequately consider its mitigating provisions and not just disparate rates of ID possession. The law permits people to vote without ID with three different mechanisms. First, people can obtain free IDs. Second, there are broad exceptions to presenting ID to vote. And third, you can vote provisionally and then return to the county board with your ID later, the so-called cure provision. First, voters without one of these IDs can obtain an ID for free at no cost at the DMV or the County Board of Elections. For an elections board ID, a voter need not present any documentation. They just provide their name, date of birth, and the last four digits of their social security number. For an ID from the DMV, anyone over the age of 17 can get a free non-operator ID. They do need to show some documentation, unlike the county board ID, but they can obtain this any day the DMV is open. Separately, for a person who had a DMV issued ID, but was required to turn it in due to a suspension or revocation, as Judge Opfalu alluded to in one of his questions, the law requires DMV to automatically send that person a replacement ID. This is in section 1.3A of the session law. Next, if a voter still does not have acceptable ID when they vote, even if they just forgot it, they can still vote and have that vote counted if they fall under 3 exceptions to the ID requirement, 2 that are narrow and 1 that is broad. First, the voter is a victim of a recent natural disaster. Second, the voter has a religious objection to being photographed. And third, the voter has a reasonable impediment that, quote, prevents the registered voter from presenting photographic identification. Now, I highlight this phrase because the set of problems that prevent you from presenting or showing your ID at the polls are broader than the problems that would keep you from obtaining an ID, which is how the exception was phrased under the prior law. For example, forgetting ID at home prevents you from presenting ID, so it would count under the new law, but it doesn't prevent you from obtaining the ID. In other words, the excuse is broader in the newer law. Reasonable impediments under the law explicitly include a number of obvious ones. Inability to obtain ID due to lack of transportation, disability, illness, lack of birth certificate or other documents required to get it at the DMV, work schedule, family responsibilities, lost or stolen ID. You applied for ID but have not yet received it. Now, in addition to these obvious examples, law also permits a voter to identify any, quote, other, unquote, reasonable impediment to presenting ID. When claiming one of these exceptions, a voter votes a provisional ballot and fills out an affidavit attesting to their identity and the fact that one of these 3 exceptions applies. Critically, law requires that provisional ballots cast under one of these exceptions be counted, quote, unless the county board has grounds to believe the affidavit is false, unquote. Under an administrative rule adopted by the state board, a determination that a reasonable impediment affidavit is false must be agreed upon by all 5 members of the bipartisan county board unanimously. And as Director Bell testified, this falsity provision is written in such a way that it is difficult to even conceive of scenarios where falsity could be invoked to reject a voter's ballot. This falsity limitation is a critical distinction from the prior law, which provided broad discretion to county boards to discredit a voter's reason that they provided, including by drawing their own conclusions that the voter's reason, quote, merely denigrated the photo identification requirement or made obviously nonsensical statements. Those reasons are not in the current law. In other words, discretionary grounds for rejecting a vote are not in this law. A third and final mechanism helps ensure a voter can exercise the right to vote. If a voter simply forgets her ID when she goes to vote, she can cast a provisional ballot and later return to the county board with an acceptable form of ID, no later than the day before the canvass of votes. That translates into a deadline of 9 days after Election Day. The ID requirements and exceptions that I just went through apply largely the same way to absentee voters. One final point on the law's provisions. There was testimony from one of plaintiff's experts, Professor Louloudis, suggesting that voters from across the state could lodge challenges to reasonable impediment affidavits. Although I have great respect for Professor Louloudis as an historian, the court should not credit his legal analysis. The state board does not interpret the photo ID law to permit challenges to reasonable impediments. That is because the reasonable impediment provision associated with the prior photo ID law, unlike this law, explicitly allowed for such challenges, terming them, quote, impediment evidentiary challenges, close quote. In other words, a voter could provide evidence to challenge someone's reasons that they gave in a reasonable impediment affidavit. This law has no such provision. Instead, only the bipartisan county board unanimously can reject a ballot cast pursuant to a reasonable impediment affidavit, and only if they all agree that the affidavit is false. Now, turning to my second major point, the state board and their 100 county boards of elections are committed to implementing this law and all the laws they enforce in an unbiased manner. They're also committed to ensuring that all eligible voters are able to cast their votes. Legally, the plaintiff's predictions about improper implementation of the law are not obviously relevant to the question of what the legislature's motivations were in enacting SB 824. In fact, the Fourth Circuit addressed this issue when it recently reversed the preliminary injunction on this law, when it said, quote, an inquiry into the legislature's intent in enacting a law should not credit disparate impact that may result from poor enforcement of the law. That's at Penn site 310 of the Raymond decision. In any event, the basic presumption in the law is that public officials will act in a fair and lawful manner, the so-called presumption of regularity. The State Board is committed to doing just that. I'll address the evidence in this regard anyway. As you heard from Executive Director Bell, when asked whether election officials will work in good faith to carry out this law, she said, "We are election professionals and election administrators. We administer the law as it is written and is in place. So I have no doubt that whatever the law is what we will administer and implement." She added, "We were prepared to implement 824 and offer the training necessary prior to the injunction, and would do so if the injunction were lifted." Former Executive Director Kim Strag also explained that election officials and poll workers across the board are committed to doing their jobs as instructed and according to the law. No one would deny that sometimes poll workers make mistakes. That is true with respect to any law that is implemented across our state's 100 county jurisdictions. But certainly, the evidence shows that the State Board has and will work diligently to train all poll workers on the provisions of this law, and in particular on two key components. One, that no voter should be turned away from the polls, not for lack of ID or anything else. Two, if a voter lacks ID, the poll worker must inform the voter of their options to still vote, as the law provides. In this regard, Section 1.5A10 of the bill requires the State Board to, I'm quoting here, "prominently place the following statement in all voter education materials mailed to citizens and on informational posters displayed at one-stop voting and at precincts on election day." The statement reads, "All registered voters will be allowed to vote with or without a photo ID card. When voting in person, you will be asked to present a valid photo identification card. If you do not have a valid photo ID card, you may obtain one from your County Board of Elections prior to the election, through the end of early voting period. If you do not have a valid photo ID card on election day, you may still vote and have your vote counted by signing an affidavit of reasonable impediment as to why you have not presented a valid photo ID." That's the end of the quote from the statute. Plaintiff's expert, Professor Ariel White, nonetheless suggested that poll workers trained at the county board level may be incapable of fair administration of the state's elections laws, and that there was widespread public confusion about the prior law. These conclusions should be afforded little weight. Professor White based these conclusions off three things predominantly. First, academic studies that are not tied to North Carolina, except for one national study, national survey that included a statistically insignificant number of North Carolina voters. Two, her admittedly limited review of how the State Board implemented the prior law. And three, on a handful of anecdotal accounts. These sources and methods produce only conjecture about how the law will be implemented at scale and are not reliable. Moreover, Dr. White testified that she did not review the actual materials used to train county boards or their poll workers. Her report cites the poll workers' desktop manual, the station guide, but as she confirmed in her testimony, the version she discussed in her report was not the one used for implementation of photo ID in March 2016. She doesn't even discuss the station guide that was in effect when the photo ID law was last implemented. The testimony of Executive Director Bell, the state's chief elections official, who is closest to this issue, is more persuasive in this regard. Again, she would never deny that some poll workers make mistakes. They are, after all, human. But that is not the basis to conclude that the law will be unfairly administered across the board. As the court observed in this trial, the state and county boards have considerable experience from the implementation of the earlier photo ID law that they can draw from in preparing the public and the poll workers for the current law. In other words, the State Board is not starting from scratch if this court upholds the law. And if the court were to uphold the law, the State Board is committed to good faith implementation of the law, as are the county boards, as they are with all election laws. In sum, the law at issue provides ample means to comply with its provisions, whether a voter possesses ID or not. Should this court uphold the law's constitutionality, the state and county boards of elections stand ready to implement the law even-handedly to ensure that everyone's right to vote is protected. Thank you, Your Honors.
Thank you, Mr. Cox. We would normally take a break around 11:45, but it's 11:35 now, and it's probably a good time to go ahead and break, Mr. Brockman, rather than to start your rebuttal closing and then interrupt you there in 10 minutes. So let's go ahead and take about a 15-minute break. We'll come back at 11:50. All right, 11:50.